Hello, everyone, and welcome to this month's webinar on background investigations, ban the box, and negligent hiring, what every employer needs to know. This free webinar is available exclusively for our compliance management subscription customers. I'm Robert Leland, the Director of Research and Product Development for Personnel Concepts, and I'm joined by my co-moderator, Kim Cabanting, who is our Managing Editor.
Hi, everyone. Our guest speaker today is Wayne Wysong, an attorney who is licensed in multiple states. Since 2000, Wayne has been a member of and counsel to the Atlanta-based law firm of Helms & Green. Mr. Wysong's practice primarily focuses on the compliance, tax, and financial aspects of employment law and employee benefit matters. He has written extensively on various topics for a number of publications dating back to 1981 and has been a practicing attorney for 35 years. His experience includes serving as an attorney for a U.S. government agency, as in-house counsel to businesses, and as a management consultant. He'll be discussing the legal issues surrounding background investigations. We initially selected background investigations as our focus topic due to recent legal developments, including a partnership between the EEOC and FTC to increase awareness of applicant rights, joint publications released by those agencies, and new ban the box laws in various states and municipalities.
Before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the chat window. Most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. Now, it is Wednesday, August 12th at approximately 10:02 a.m. Pacific Time, 1:02 p.m. Eastern Time. In the event of technical difficulties, the co-moderators and the guest speaker will re-record this webinar and send it to all registered participants. The format today's webinar is a series of questions we'll be asking to Wayne about the legal issues pertaining to background investigations and how to prevent negligent hiring claims. With that, let's get started with today's presentation.
Wayne, our first question is about claims of negligence pertaining to the hiring process. What exactly is negligent hiring?
Well, good morning, Kim, in California, and good morning or afternoon, that's appropriate to the rest of our attendees. Negligent hiring occurs when an employer knew or should have known about the employee's negative or dangerous background, assuming he has or she has it. It is considered a tort, which is an actionable wrong, and sue for it. And the injured person can sue not only the person who caused the injury for it, but the person who negligently hired that individual. This will more often than not happen as such tort lawyers follow the deep pocket theory, you may have heard it, under which they try to join the person or companies that are most likely to be able to pay. The individual who brings the claim has to prove that the behavior leading to the injury was consistent with past behavior, which revealed that the hired employee, or should have revealed, had they checked, was somehow a menace, dishonest, a rapist, or other sexual predator, a thief, child molester, or any other kind of dangerous past conduct relevant to the victim's injury. Customers and employees alike have a right to expect a safe workplace, and it is legally the employer's duty to do as much as possible to ensure that it is.
Wayne, what mistakes do employers make in the hiring process that could potentially expose them to future negligent hiring allegations?
Well, Robert, I think the most obvious one is not running a criminal background check. Although, as we will see, new laws known as ban the box laws may somewhat limit an employer's right to do such checks and the timing when they can do them. Others include not checking past employment history or not requesting personal references, not confirming alleged educational credentials, not inquiring about employment history, and where possible, not interviewing former supervisors. Now, let me add here that a lot of employers have a policy of not giving out information about former employers other than hire date, periods of work, and date terminated. And they won't say much more because of concern about slander laws. And that's probably more the norm than the exception now. So the former supervisor thing, I wouldn't put a lot of stock in, but it's a base that should be touched. Now, let me add a cautionary note about older workers. As all of you know, as HR professionals, it's against the law to discriminate against older workers. And you may run into occasions, particularly with high-level professionals who have been self-employed for lengthy periods before they were considered for hire, and they may no longer have information on supervisors simply because they've not had one in so long. If you've been a managing partner of a law firm or a medical practice or an accounting firm, or you've been a sole practicing dentist, your former supervisors could be deceased or the name's forgotten. The former supervisor may not even remember the former employee, or maybe retired, may be deceased, or the company they worked for together may no longer even exist. So employers must be very careful and use caution in this area about employment history and interviewing former supervisors when dealing with older employees or older candidates who have not worked as traditional employees for a while. Insisting on contacting former supervisors in some cases or requiring references from prior periods of employment could actually result in age discrimination claims. And it may also unwisely screen out some of the most seasoned, best qualified applicants. So I just wanted to mention that as an aside. Depending on the nature of the employee's job or the employer's industry, drug screening may be necessary to minimize the risk of harm. Credit checks may be important too, especially if the employee is going to have high-level financial responsibilities. Even driving records should be considered in many cases, such as whether the occupation involves driving passengers or customers.
Now, in several states and municipalities have passed so-called ban-the-box laws over the last 2 years. What are ban-the-box laws?
Good question, Kim. The heart of the matter. And the box, I guess the first thing to understand is the box is the part on the job application that says, have you ever been convicted of a crime? And they address the question of, is it right or fair that a petty or non-violent offender, such as a drug user or one-time no-accident drunk driver, should have their job opportunities ruined for life because of their conviction and the background check practices of employers? Ban-the-box laws, sometimes called fair chance laws, seek to address that question. The box in question, as I said, is that application question, have you ever been convicted, blah, blah. Astonishingly, nearly 25% of Americans have an arrest or conviction on their records. The majority of these offenses are nonviolent. Between aging workers leaving or being forced out of the workforce and the increasing ban on any type of job candidate with any blemish on his or her record, employers are actually driving themselves towards a labor shortage and pressure to pay higher wages.
Wayne, with regard to ban-the-box laws, do these laws basically force employers to hire people with a criminal record to avoid discrimination claims?
No, Robert, absolutely not. These laws do not mandate the hiring of any person with a criminal record. Employers are usually still permitted to do background checks. What these laws change is the timing of the check. Typically, it postpones it until later in the hiring process. the law does not require an employer to hire any candidate with a criminal background. Ban the box simply requires the employer to wait until later in the process, typically until either the interview phase or before a conditional job offer is made. The laws vary from state to state, locale to locale. But the idea is that the applicant is not summarily ruled out on initial interview of the application, and at least has a chance to display his or her qualifications or voluntarily raise and tell his or her side of the story if asked.
So we mentioned that several ban-the-box laws have been enacted over the last 2 years. Wayne, which jurisdictions currently have ban-the-box laws?
Oh my goodness, Kim. I don't know if everybody wants to write this down. There's a link you guys can provide.
Actually, before you go into this, Wayne, I just wanted to mention to the attendees that if you click the Handouts tab on your GoToWebinar menu, there is a document with some online resources, including all of the links that Wayne is going to be offering as good resources for attendees to view this information. So, Wayne, the link that you're going to mention is available in the handouts.
Good, good. Yes, it's a website that surveys and tracks ban-the-box laws because they're constantly changing, and it shows you the latest status on every state. So I would recommend that to everybody who's concerned with this topic. But to answer your question, Kim, it varies quite greatly. Some states have no such law, although I think they're the minority. Some have statewide laws, and some have only local ordinances in various cities and counties. The last update I've actually looked at is January 2015. And at that time, the states which had statewide laws where certain local jurisdictions within those states have even more stringent requirements are the following: California, Connecticut, Delaware, Illinois, Maryland, Massachusetts, Minnesota, New Jersey, and Rhode Island. States that have only a uniform state law are Colorado, Hawaii, Nebraska, and New Mexico. Finally, there are a number of other states that have no state law, but ordinance enforced by various cities and counties. These states are Arizona, Florida, Georgia, Indiana, Kansas, Kentucky, Louisiana, Michigan, Missouri, New York, North Carolina, Ohio, Oregon, Pennsylvania, Tennessee, Texas, Virginia, Washington, Wisconsin, and of course, good old Washington, D.C. So as you can see, they're pretty widespread, and they're not all the same. Obviously, this makes it a very confusing environment for an employer to navigate. So it behooves all employers to review the cited website, which is updated regularly, as I mentioned, to determine what their obligations are in their area of operation. There's growing momentum for such laws and is not likely to subside.
Hey, Wayne, are there any federal laws addressing applications and criminal records as well?
No, there are currently no federal ban-the-box laws. Federal law pretty much only regulates federal jobs. At the federal level, the EEOC has stated that removing the criminal conviction question from all job applications was consistent with what they call best practices in reducing the chance of illegal discrimination. One of the reasons it's taking this position is that criminal conviction rates tend to be tilted towards certain races and other protected groups, so summarily refusing to even consider members of such groups without even interviewing them could leave the employer vulnerable, most critically to race and national origin discrimination allegations. Federal or state laws may still require background checks earlier in the process. Ban-the-box laws do not change this, and ban-the-box laws do not require the hiring of people with convictions. convictions relevant to the job. For example, a child care center does not have to hire a person convicted of child molestation. A school district or bus company is not required to hire a person convicted of felony drunk driving for a bus driver position, and a consulting business is not compelled to hire a person convicted of sexually molesting an office coworker.
So are employers required to notify an applicant or employee prior to running a background check?
To some extent, yes, Kim. The provisions of the Fair Credit Reporting Act govern a lot of this. A prospective employer may not legally run a credit check or a criminal background check on a candidate or an existing employee for that matter, such as when considering somebody for a promotion, without first disclosing to the individual, orally or in writing, that it's going to do so. The information the employer must provide includes, first, the name, address, and phone number of the company which supplied the credit report or background information. 2, a statement that the company that supplied the information did not make the decision or take any adverse action and cannot give you a specific reason for the decision. And 3, provide a notice of the right to dispute the report's accuracy or completeness, and to receive a free report from the company that supplied the report or other background information, and to receive a free report from that company if requested within 60 days.
Before we proceed, for those that may have joined late or just joined, we're talking with Wayne Wasong about background investigations, ban-the-box laws, and negligent hiring. A recorded version of this webinar presentation will be sent to all registrants later, so if you missed the beginning, you will receive a recording at the conclusion of today's webinar. Wayne, my next question is, why would an employer want to do a credit check as part of the background investigation process?
Well, Robert, it depends on the nature of the business. Banks, brokerages, government, and financial institutions may routinely investigate credit history to determine whether the candidate or employee poses a risk of fraud or embezzlement. Accountants and money managers are also often subjected to credit checks to determine if their personal financial situation presents a risk of dishonesty in the performance of their jobs. Another concern employers have is whether the employee's credit picture might distract them from giving proper attention to the job, and they may use this information to help distinguish between individuals as to which is lower risk. Another factor for employers is income and the honesty of the candidate's job application. Suppose an employee represents he has earned over $120,000 per year for the past 10 years. Yet his or her credit report shows a bad history of creditworthiness. Could that indicate the candidate is lying about his past earnings history? And if so, what else might that person lie about? There are limitations. First, the employer must obtain the candidate or employee's written consent to running the credit check. This is required by the Fair Credit Reporting Act. One interesting twist, and one that neither employees nor employers are often aware of, is that credit reporting agencies will not provide employers with the individual's 3-digit credit score. That information is only available to lenders. The report the employer receives also will not include the candidate's or employee's date of birth. But here, as an aside, are some interesting facts about the use of credit reports by employers. While many routinely request them, few employer personnel actually understand them. Most HR personnel cannot properly interpret the information on a credit report and focus only on whether there are bankruptcies. The great majority of employers allow applicants an opportunity to explain any credit problems uncovered and are seldom swayed in the hiring decision by their credit report alone. Credit reports are often, if not usually, obtained only to show due diligence in the hiring process in case the employer is sued for negligent hiring or dishonest acts by employees. And finally, only a small percentage of employers actually even look at the credit report, simply filing it away. If an employer does a credit check on a candidate and does not hire the individual, the Fair Credit Reporting Act requires the employer to provide written notice of the hiring decision and the name and address of the consumer credit reporting agency used, whether or not it was a factor in the hiring decision or even examined.
So can employers perform criminal background checks for all positions?
The extent to which employers may conduct criminal background checks varies greatly from state to state. So the prudent employer should consult with a local attorney in deciding the extent to which it may delve into criminal history. I will say this, lie detector tests are generally prohibited by the Federal Employee Polygraph Protection Act, with the primary exceptions being armored car services, alarm or guard services, or businesses that manufacture, distribute, or dispense pharmaceuticals. The great majority of employers, approximately 92% according to one source I read, do conduct some type of criminal background check. Employers need to know that federal consumer protection law gives applicants the right to see and correct any erroneous information on a criminal background report. The same is true with credit reports.
Are there any restrictions on what employers can access during a background investigation?
Many states afford applicants some protection from disclosure about their criminal records. A very common prohibition is asking about arrest records where charges are no longer pending. Other states allow only job-related criminal records, such as theft records for a bank teller. Still others require employers to take into account various mitigating circumstances or participation in rehabilitation programs, as well as the severity of the crime itself. Let's take California, for example. It has more restrictions on access and use of criminal records pertaining to job seekers than most other states. Employers may not ask about a prior arrest if it did not lead to a conviction. Participation in pre-trial or post-trial diversion programs are also off limits. Convictions which have been sealed or expunged or eliminated by operation of law are also disallowed areas of inquiry. Older marijuana offenses are not subject to inquiry. The major exception is that if the conviction relates to the job, the employer may inquire. The employer may also ask about arrests for which a trial is pending. So I guess, Bob, there's no one-size-fits-all answer to your question, but laws differ a lot from state to state on how far they can delve into criminal records, although all states permit some degree of criminal background checking.
So Wayne, what does the EEOC say about background checks?
Well, the EEOC's primary concern is that background check policies can operate to create employment discrimination against certain categories of workers, particularly African Americans and Latinos. EEOC's statement of position on this question can be found at the link. It's the second link you're providing, I believe. I encourage everyone to look at it. The EEOC's guidance applies not only to hiring, but to promotion, retention, and reassignments. One thing it points out rather strongly is an employer should never, and I emphasize never, inquire about medical history or genetic information. The privacy of this information is protected by the Federal Genetic Information Non-Discrimination Act of 2008, also known affectionately as GINA. If the employer is using an outside company to conduct the background check, it's the employer's responsibility to assure that the company it uses complies with the Fair Credit Reporting Act and the regulations of the Federal Trade Commission. Social media checks are not strictly forbidden, and employers need to be aware of various state laws that limit the right of an employer to demand an employee's or candidate's social media account password. The EEOC completely objects to running different types of background checks on different types of people. So an employer must not subject any racial, ethnic, age, or religious group or any disabled persons to more stringent checks than other groups. Men and women, obviously, must undergo the same checks. However, different levels of background checks can be conducted and sometimes must be conducted for different types of jobs. As a general rule, though, all persons seeking a particular type of position should be subject to the same type of background check. A specific example of an unlawful practice highlighted by EEOC is asking people of one race for their financial information, but not persons of other races. The EEOC also requires the results of background checks to be maintained in the employer's records for at least 1 year after the later the time the record was made or the hiring decision. The employer is a federal contractor with at least 150 employees and an outstanding contract of at least $150,000. The Department of Labor extends this requirement to 2 years, which is also the case for government agencies and educational institutions. Credit reports can be disposed of when no longer being used, but must be done so securely.
Wayne, what are some things that employers can do to make sure their background check procedures are in compliance?
Well, first of all, do them. Do background checks and do them as appropriate to the position involved. Familiarize responsible personnel, such as the HR department, to the requirements of not only federal, but state and local laws regulating background checks. As I said before, there is no one-size-fits-all solution. Multiple state businesses operating in more than one state, will very likely have to establish different background check practices for each state. And the same is true for businesses in more than one city or county in the same state. They should coordinate the company's background check policies with the company's EEO policies and seek the input of the company's EEO officer, if it has one, but if it does not, it should if it's large enough. Examine existing background check practices and adjust them as necessary to meet current requirements and restrictions. Monitor legal developments regularly as background check requirements are in a constant state of flux. In particular, regularly check the Ban the Box website referenced in this article. And finally, retain good labor counsel to assist with compliance.
Thank you, Wayne, for reviewing this information with us. Before we end this session, let's take a moment to answer some questions from our audience that were submitted during the presentation. Robert will ask the questions on behalf of our attendees.
Thanks, Kim. We have quite a few questions submitted by the attendees during the presentation. The first one comes from Marlene. Regarding the Ban the Box laws, do you recommend not mentioning on the ad that a background check is being conducted if considered being hired?
No, I think it's totally appropriate on the application that background check may be required. And just don't be real specific about what it will entail. But I think as a standard form, you could put there all applications subject to legally allowable background check. I think that's a wise practice, but again, how far you can go will vary from locale to locale.
An attendee by the name of Carlos wants to know, is it safe to state in an application form that I agree to submit to drug screening tests, a criminal background check, or any other type of background check upon request?
I think so, yes. I think the key word there is background check. But remember the ban the box law and the timing. You can have the employee acknowledge that he may be subject to a criminal background check. But the thing that ban the box doesn't like, if it applies in your jurisdiction, is don't have a question on the application saying, have you been convicted of a crime? But it's quite acceptable to say, understand that you may be subjected to a criminal, etc. background check.
An attendee by the name of Aaron wants to know, if we hire someone who is in state and we complete a criminal background check from the state of Alaska, but the majority of our employees come from out of state, what do you recommend we do for a background check for these candidates?
Well, I'm a little confused by the question because when she says these candidates, I'm not sure she means Alaska or the other states, so I'll try to address both. The law that will apply in these cases is the law of where the person is going to be employed. So it doesn't matter whether the company is headquartered in Houston, Texas, or Chicago, Illinois. Workers in Alaska who will work in Alaska will be subject to Alaska's laws. Workers in California will be subject to California's laws, and so forth. So they will have to, in their hiring, they will have to comply with the state and local laws of where the people are being hired and will work. I think that's the best answer I can give.
One attendee would like to know, or just verify, does GINA only apply to businesses with 15 or more employees?
Could I get that? I apologize. I don't know the answer to that question off the top of my head. But if you could get that lady to provide me her email address, I'll check it and send it to her. I just don't recall. I know the great majority of employers are subject to it, but
yeah, our
really
understanding is that the non-discrimination provisions of GINA apply to businesses with 15 or more employees.
Well, be right.
But the health-related provisions may apply to businesses with less than 15. But Wayne, if you can confirm that, and if we can we'll get the answer to the attendee shortly after the webinar.
Okay, will you send me her address or some means of reaching her?
Yep. Okay, that covers the majority of the questions that have been submitted by our attendees. I just want to take a few moments before I pass it back over to Kim to remind all of you that if, as a subscriber to our compliance management subscription service, you've all received a digital workplace compliance library CD-ROM that does have in-depth information about background investigations and negligent hiring, including materials compiled from various government agencies, a legal brief from Wayne, consent forms, forms to fulfill the FCRA's requirements, including the summary of consumer rights. So that information is available on your digital compliance library CD-ROMs as a compliance management subscription customer. Kim?
Okay, this concludes today's webinar. Thanks everyone for attending today's presentation. We hope you found this information useful in understanding the various legal issues associated with background investigations and pre-employment screening practices. Thanks again to Wayne Wysong for being our guest panelist. We look forward to continuing to work with Wayne on future presentations. And to all of our attendees, thanks for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a great day and a good week. Thanks, everyone.
Thank you.
Thank you.